my name is Alexis Eykel. I'm the Landlord Engagement Specialist at Tacoma Housing Authority. Thank you all for joining us this afternoon to learn about the Pierce County Eviction Resolution Pilot Program requirements. As of today, we are joined by our friends at the Housing Justice Project, Lori Davenport and William Beck, and also Jim Henderson, who is the lobbyist for National Association of Residential Property Managers, Pierce County Realtors Association, and Rental Housing Association of Washington, and also the president of Landlord Solutions. So the way the webinar is going to work is we are going to start with our presentation. It is being recorded, and then we will pause at the end and open it up for questions and answers, and we will pause recording as well. So I'm going to go ahead and turn it over to William.
Thanks, Alexis. Hey, everyone. Thank you for joining us this afternoon. Jim, Lori, and I are here today to talk about a pretty significant change that's come about in the landlord's laws and the procedures that we use in non-payment of rent cases with the end of the repayment plans under RCW 5918-630 and the end of the eviction resolution pilot program. I'm going to go ahead and share my screen so the slides up here. All right. So as I was saying, we're going to discuss today the end of the repayment plan requirement under the RLTA and also the end of the eviction resolution pilot program, particularly what that means for landlords and for tenants. These have been a couple of requirements that have been in place since the new law changes in 2021 as we emerge from COVID and the eviction moratorium. And so really we're seeing a significant step away from the protections that were in place and put into place during the eviction moratorium and as we near the end of the pandemic. So first, we'll discuss the end of repayment plans under 5918-630. Recall that under this requirement, a landlord has to serve a reasonable schedule for repayment for any unpaid rent that accrued between March 1st, 2020 and 6 months following the expiration of the eviction moratorium or the end of the public health emergency, whichever is greater. So on October 31st, 2022, the public health emergency ended by the governor's proclamation. So we count on 6 months from that date, which takes us to April 30th. So as of April 30th, any arrears accrued past that date would not be subject to the repayment plan requirement. Now, there's a key distinction there because the language that exists in 632 does not mean that repayment plans are no longer required past that April 30th date. Rather, what it means is that if there's any rent accrued after April 30th, that rent itself is no longer subject to the repayment plan requirement. But if there is remaining unpaid rent that is accrued prior to April 30th, that unpaid rent is subject to the repayment plan. So there's a couple of examples I've included here on the slides. One, if a tenant owes rent from March 2023 to July 2023, under the plain language of RCW 5918-630 subsection 2, the landlord has to offer a repayment plan for March and April's rent. Now, strictly speaking, the landlord wouldn't be required to offer a repayment plan for the rent that is accrued for May, June, or July, but for March and April, there would be a repayment plan required. A second example in contrast, if a tenant owes rent for June and July, but nothing prior to the April 30th date, there's no requirement that a repayment plan be offered. And so we won't get into the specifics of what's required for a valid repayment plan now, since we're nearing the end of that requirement. But for the landlords that may need to serve a repayment plan for arrears that are accrued prior to April 30th, I'm including this information on the slides so that they can be referenced later. Some of the requirements include that the payment can't be required until at least 30 days after the repayment plan is offered to the tenant. It has to cover rent only and not late fees, attorney's fees, court costs, or any other fees or charges. And they must allow for payments from any source of income or from pledges by nonprofit organizations, churches, religious institutions, or governmental entities.
And Will, I'll make one reminder to the housing providers that while we have been using a standard of 1/3, remember that's the maximum. So if your resident comes back and they can show you that based on something, increase in expenses or decrease in income related to COVID, then you need to consider their offer of something that might be less than your original offer at 1/3.
Thanks for including that, Jim, because I realized now there was an and at the end of my last slide, and that's probably what that and was going to put in there. Also, so on the flip side, we talked about the requirements, some prohibitions on a valid repayment plan. Just as a reminder, the repayment plan offer cannot be contingent upon the tenant's compliance with the rental agreement, payment of attorney's fees, court costs, or other costs. If that tenant defaults on the rental agreement, it cannot require that the tenant apply for governmental benefits or provide proof of receipt of governmental benefits. And it cannot include a waiver of the tenant's rights to a notice, so a notice to pay or vacate before a writ of restitution is issued. And if there are any of those prohibited provisions within a repayment plan, or it fails to comply with the requirements we covered on our last slide, it could be a defense to an eviction for non-payment of rent if the tenant is then named as a defendant in an unlawful detainer proceeding. Jim, is there anything you wanted to add on that slide?
No. That's good.
All right, so I think the biggest question for our audience today is what happens if a tenant agrees to a repayment plan, but then has accrued unpaid rent after April 30th, 2023? So similar to the first example that we covered a couple slides ago, what if we have a split in rent arrears where some of the arrears are covered by a repayment plan, but the other amount of arrears would not be covered by a repayment plan? So I think it depends. Technically speaking, the landlord has complied with its duty under the repayment plan requirement. If a repayment plan is offered for arrears that are accrued prior to April 30th, but then not including any arrears that have accrued afterwards. And I think the landlord would be justified in going forward with an unlawful detainer action for the remaining balance owed. However, in that case, if a judgment is going to be entered for the arrears in an unlawful detainer proceeding, that judgment probably would not include the arrears that were subject to the repayment plan, because those arrears already have some form of agreement that's in place to address those arrears. I think no matter how we look at this situation, because of this weird transition period, and because that we don't have anything in the law to kind of accommodate this transition period, we have a temporarily messy situation for both landlords and tenants. All right, so in addition to that end of the repayment plan requirement, we also have the end of the ERPP, which many of you know are familiar with. That's the Eviction Resolution Pilot Program under 5918-660. It's been around again, mainly through the new laws that came about in 2021, but even a little bit before that. Initially, I believe it was introduced as a voluntary program before the new laws. But as we emerged from the pandemic, it became mandatory under RCW 5918-660. And so through the ERPP, which was operated by the dispute resolution centers, including here in Pierce County, the CDR, the idea of ERPP was that it would be used as a mandatory program to facilitate discussion and settlement between landlords and tenants prior to an unlawful detainer action. Now, since we emerged from COVID and since these new laws came about in 2021, the ERP was required to be used for all non-payment of rent cases before the landlord could file an unlawful detainer action. And so in addition to using the ERPP, the landlord also was required to provide an ERPP notice with that notice to pay or vacate. And at the time of serving the notice to pay or vacate and the ERPP notice, the landlord had to serve copies of both notices to the CDR. So many of you are familiar with the ERPP notice. If you're not, this is the form that we use here in Pierce County. Now, these requirements for ERPP participation, notice, and certification expired on July 1st, 2023. So what does this mean? As of July 1st, 2023 and going forward, landlords are no longer required to serve ERPP notices with pay or vacate notices. And in addition, landlords are no longer required to participate in ERPP, nor obtain certification of ERPP participation prior to filing an unlawful detainer action. Jim, feel free to stop me as well. With the way my screen share is working, I can't actually see your face. So if you're giving me facial indications, I can't tell. So according to the CDR's website, CDR is no longer processing ERPP notices and cannot issue or revise certificates regardless of the date submitted. However, voluntary conflict resolution services are still being offered by the CDR. So landlords and tenants that are interested in voluntarily participating in mediation or conflict resolution services through CDR can still do so. I think those services began on July 17th. And this is still pretty cool. It remains to be seen how often that's going to be used by landlords and tenants, but it's an option that wasn't in existence prior to ERPP. In the times prior to ERPP, the parties could seek mediation through CDR, but it would come at a cost. And so these services are being offered at no cost. And so if landlords and tenants, if you're inclined to use this as an alternative means of resolving a dispute regarding non-payment of rent, you still have that ability. So the link is included here in the slides.
I want to add one note here that while this presentation, while we're talking about a statewide law, it also the CDR program is local. So just know that if you're listening to this and you are in outside of Pierce County, you need to just double check what the local rule is on your dispute resolution center and how that operates. Because it could be slightly different as it currently is a little bit different in each county.